The given passage here is followed by 5 questions. It begins by discussing the quality of justice that is given to the people in The Hague. It says that unlike the past trial by jury system, The Hague now relies on judges. As a consequence of which the judges are not guided by any of the cases judged by judges in the past, and are also dispensed with the traditional procedural safeguards and then in the second paragraph, the passage goes about criticizing Rule 61 made by one such judge. Then it goes about discussing what happens in that place in order to condemn Balkan wrongdoers, as a consequence of which prosecution wields a lot of power in comparison with the defense. And the fourth paragraph discusses that what the ideal situation should be. Ideally, the defense and the prosecution should be on equal footing, but that's not really the case. Then the passage goes about discussing Yugoslavia Tribunal, which also, like that of The Hague, gives very little right to the accused, and supports this idea, this claim, by giving an example of Jean Bosco. Now let's look at the questions that follow. Question number 1 says, which of the following statements is correct with reference to The Hague and the jury system? The jury system is not followed in The Hague since it's considered archaic. This is absolutely correct. The reference to which is given in the very first paragraph, which says that the tribunal does not need to shackle itself with the ancient trial by jury system. Therefore, option A follows. B says hearsay evidence is admissible because there is no jury. The first paragraph also talks about hearsay. It says that since there is no ban on second or third hand hearsay evidence, for example, because it is argued judges are better equipped than juries to weigh the merits of such testimony. That means since judges are better equipped to weigh the merits of the testimony of the third and the second hand hearsay, therefore the court in The Hague allows second and third hand hearsay evidence, right? So therefore A and B both are correct. So our answer is option C, both A and B. D says in a scenario with no rules, the jury system is dysfunctional. First of all, the jury system does not function in The Hague, and therefore it is absolutely incorrect. It is factually incorrect, so option D can be eliminated. The second question says, which of the following best describes the author's attitude to the clause permitting conduct of trials in absentia? Now look at the second paragraph of the passage. It talks about Rule 61, which according to which the tribunal, if a Balkan government refuses to turn someone into The Hague, Rule 61 allows prosecutors to present highlights of their case against the accused in their absence, in the hope that bad publicity will compel the authorities to hand them over. Now the author says this practice is tantamount to a mini trial in absentia, but worse, because defense lawyers are banished from courtroom. Now the author considers the situation of defense lawyers being banished from the courtroom as a worse situation, and therefore he is completely against trial in absentia, and therefore the author's attitude to the clause permitting conduct of trials in absentia is critical. He is criticizing it. Supportive, absolutely not. Optimistic, no. Neutral, no. The author does hold an opinion against the trial. The third question says, according to the passage, which of the following does not show that the office of the prosecution wields considerable power? Now the given question gives reference to Biljana Plavšić, Slobodan Milošević, General Tihomir Blaskić, reference to which is given in the third paragraph. It says that it says that in the push to condemn Balkan wrongdoers, the office of the prosecution wields considerable political influence. Then it goes about giving examples. It says its leader Carla Del Ponte has the power to bring national leaders to the book. So clearly this is not an example of the office of prosecution not wielding considerable power, but rather the very opposite of it. Then further it says in January it gives examples of Carla Del having the power to bring national leaders to book. What are the national leaders she brings to book? She summoned Biljana Palcic, so option B is also therefore incorrect. The former president of Bosnian Serb Republic to the Hague. 6 months later she had also lined up Slobodan Milosevic, so this also cannot be correct because of the same reason. When her predecessor Louis Aba won a case compelling the Croatian government to hand over General Tihomir Blaskic, she recalled that people in her office stopped whining, saying there's no political will, no one helps us, because they suddenly realized that they had a huge amount of power. So clearly the prosecution of General Tihomir Blaskic is the prosecution and the conviction of General Tihomir Blaskic makes people feel that they enjoy a huge amount of power. So clearly it is a case against, it's an example of the prosecution not wielding considerable power, and therefore is the correct answer. Question number 74 says, the next question says, according to the passive, which of the following statements is the author most likely to agree with? First says the inequality in the status of the defense and the prosecution at the Hague is justified. Clearly the author thinks that this difference, this inequality between the two is not justified, and therefore option A can be eliminated. The structure of the court is correct in favoring the prosecution over defense, same thing, can also be eliminated because of the same reason. C says the inequality between the defense and prosecution should not be present. Absolutely, the author is completely in favor of the author is completely against this inequality. D says the inequality is remedied by the national governments which extend preferential treatment to the defense. So if this is not possible, because if the national government is giving preferential treatment to the prosecution, then it cannot be giving preferential treatment to defense also. Therefore it is absolutely incorrect. Therefore the correct answer is option C. The next question says, why does the author regard the release of Jean Bosco as a moment that toppled the UN International's Criminal Tribunal from its human rights pedestal? The answer to this is given in the penultimate paragraph. It says that on 3rd November 1999, it was toppled from its human rights pedestal when the appeals chamber ordered the release of genocide suspect Jean Bosco Barayagwiza on the grounds that his fundamental rights were repeatedly violated. So why was he released? He was released on the grounds that the fundamental rights of the suspect were repeatedly violated, and therefore the answer to this question is the genocide suspect was released because his fundamental rights had been violated, which is option A. B says the genocide suspect was released after being found not guilty due to mishandling of the evidence not given in the passage. C says the release of the genocide victim happened because there was no judge available for the hearing. No, not there. The release of the genocide suspect occurred due to power game between the prosecution and the defense. Absolutely incorrect. So therefore the answer is option A.